Good morning and good afternoon, everyone. Welcome to join the webinar Innovation and Competition, IP Trends and Challenges, one of our science diplomacy event series. My name is Li Bing and I'm the head of academic relations at SwissNext China, Science Consulate of Switzerland in China. We connect the dots between Switzerland and China in education, research, and innovation. SwissNext network is located in Boston, San Francisco, India, Brazil, and China. This year, we celebrate our 20th anniversary. Today's webinar is organized in collaboration with SwissCham Shanghai, and we are very delighted to have its board member, Ms. Sabine Neuhaus, to join us as moderator. She is lawyer and associate at Keller Harhad, the second largest Swiss full-service law firm. She advises clients in the areas of international arbitration, cross-border merger and acquisition, and commercial law. Ms. Neuhaus is co-chair of the legal committee and vice chair of the SME committee of SwissCham Shanghai. Moreover, she is the co-chair of University of Zurich alumni chapter in Shanghai. Now I'd like to give the word to Sabine. The floor is yours.
Thank you very much, Li Bing, for the kind introduction. And good afternoon and good morning to Switzerland, dear guests and esteemed speakers. It is a great honor to moderate today's Science Diplomacy webinar on innovation and competition, IP trends and challenges. I would like to thank SwissNext for the kind invitation and for the organization, in particular to Felix Mösner and Li Bing. I also thank SwissCham for supporting this webinar. I am excited to now take you through the latest international developments in innovation and competition. The field of intellectual property is a key topic in international trade and business. With the rapidly evolving technologies and artificial intelligence, the protection granted through intellectual property rights plays a crucial role. It is there to incentivize businesses to achieve unprecedented breakthroughs in technologies that advance society and change our lives. However, technology does not stop at borders. Neither do IP rights. So the protection of IP rights across borders is only as good as its enforcement when copycats are infringing them. Today, we will hear from our keynote speakers about the most recent developments in these fields. Our speakers will share with us key insights on IP protection in cross-border e-commerce trade, the balancing of interests in legal frameworks governing artificial intelligence, and on IP infringements. We will now move to the introduction of our three speakers. Our first speaker is Professor Dr. Ming Xu. He is an associate professor at the Shanghai International College of Intellectual Property at Tongji University. Professor Dr. Ming Xu has been involved in numerous research projects involving blockchain theory, the developmental status and countermeasures of China's patent system, the protection of consumer information rights, as well as patent portfolio valuation and competitive strategies based on patent asset indexes. He has written extensively on the European patent system and on patent competition strategies of technology enterprises. Welcome, Dr. Ming Xu.
Oh, thank you.
Our second speaker.
Oh, sorry.
I'm sorry, no worries. Our second speaker joining us from Switzerland is Professor Dr. Peter Georg Picht. He is the chair for business and commercial law and the head of the Center for Intellectual Property and Competition Law at the University of Zurich. Professor Picht studied law at Munich University and Yale Law School. He did his PhD summa cum laude at Munich University and the Max Planck Institute for Innovation and Competition, and he holds a master's degree from Yale Law School. He has been working with the EU Commission's Directorate General for Competition as a senior research fellow with the Max Planck Institute for Innovation and Competition, as well as with two international law firms. Professor Picht now holds a chair for commercial law at the University of Zurich. Welcome to you, Professor Picht, in Switzerland. And last but not least, we have our third speaker, Mr. Melvin May. He is a qualified Chinese lawyer, a patent attorney and trademark attorney at Lusheng Law Firm, a member of the Rouse Network. He works closely with overseas and domestic clients and provides pragmatic and commercial advice on IP acquisition, exploitation, and enforcement to solve clients' business problems in China. With over 10 years experience, he leads teams in managing trademark portfolios for clients covering a wide spectrum of industries and represents them in various trademark and patent proceedings before the China National Intellectual Property Administration and courts. A very warm welcome, Mr. Wei.
Thank you.
So after the 3 presentations, we will have time for a Q&A session, and I kindly invite our audience to share their questions by using the Q&A function, which you find on the bottom of your page after we have started the Q&A. So with that, I would like to pass the word to Dr. Ming Xu to share with us the first keynote speech.
Okay, thank you, Sabine, and thank you, everyone. I'm very honored to share some IP issues through Swiss Next webinar. My name is Xu Ming, and I'm the Associate Professor from Shanghai International College of Intellectual Property at Tongji University. My topic today is about the intellectual property protection of cross-border e-commerce in China. With the development of e-commerce, especially cross-border e-commerce, IP protection is facing new challenges. So we have a new law, the e-commerce law of China comes into force from January the 1st, 2019, which provides some regulation on IP protection. So my topic is about the first one is about the IP risk of e-commerce platform. In China, the most famous e-commerce platform is Alibaba, which provides channels to Chinese companies to sell products to abroad or foreign companies to sell products to China. And in recent years, more and more cross-border e-commerce platforms have begun to emerge, which makes it easier to sell IP infringing products through cross-border e-commerce platforms. Okay, next slide, please. Generally speaking, the IP protection of e-commerce involves 3 legal subjects, which are platform, in-platform stores, and IP holders. The platform shall develop rules for IP protection and strengthen cooperation with IP holders. For example, it needs to stipulate the terms of IP protection with in-platform stores and request for the proof of IP rights when necessary. At the same time, the platform should provide channels to IP holders. When IP holders discover infringing products, they can notify the platforms and request them to take necessary action. Next, please. When the IP holder considers that his or her intellectual property has been infringed, he can notify the platform to take necessary measures, such as deletion, blocking, or disconnection of links. The notice is very important. It shall include prima facie evidence that the infringement has been committed. Sorry, the last slide. The platform should also forward the notice to the in-platform store. This is to provide an opportunity for the in-platform stores to explain and also to prevent error notice from IP holders. Next. Even not receive the notice from IP holders, if the platform knows or should have known that an store infringed any intellectual property right, it also needs to take necessary measures. Next. E-commerce platform is very important in cross-border e-commerce. So here are some advice to the platform. The first one is provide IP compliant channel to IP holders, and then establish a rapid dispute resolution mechanism for intellectual property. because all measures need to be timely. So a large number of personnel are needed. If possible, hire a professional in-house IP team, or you can cooperate with local professional IP law firms. Next. Next, I will discuss the IP risk of in-platform stores. In-platform stores include natural persons or legal persons which sell products or provide services through the platform, such as companies that operate online stores on Alibaba International Station. If the platform sells products itself, then it is both a platform and an in-platform store. So the picture on the right hand is some example of the in-platform stores. Next. After received the forwarded notice, an in-platform store may give a declaration of non-existence of infringement to the platform. That is to prove what they are selling are not IP infringement products. The declaration is also very important. It shall include prima facie evidence of non-existence of infringements. After the platform received the notice from the declaration from the in-platform stores, then the platform should forward the declaration to IP holders and advise them may file a complaint with the relevant authority or bringing an action in the People's Court. Next. Next is within 15 days after the forwarded declaration reaches the IP holders, if the e-commerce platform does not receive further notice that IP holder has filed a complaint or sued in the People's Republic's court, the platform should terminate the measures it has taken. So 15 days is a very important time period in China in e-commerce law. If no further action was taken by IP holders within 15 days, the platform should reconnect the link in time. This is to prevent the malicious complaint from IP holders. Okay, next. Doing business through cross-border e-commerce platform is very convenient, but here are also some advice to in-platform stores. The first one is the most important thing. Do not sell infringing products because it is very easy to get the evidence. And if possible, operate online stores on different countries' e-commerce platform. If one store is closed, the others can still operate normally. If the operators receive a malicious complaint, then they should submit supporting materials to prove what they are selling are not infringing products. You can also ask the malicious complainant to bear the liability for composition. In China, civil liability shall be assumed for any damage caused to the store by error notice. If the error notice is given in bad faith, that will be double compensation liability. Okay, next slide. Next slide, please. Okay. And nowadays, in recent years, China is implementing the Belt and Road strategy. Companies from Belt and Road countries can enter China market through cross-border e-commerce platforms. But what needs to be noted is that the IP protection has regional restrictions. If a company only applies for intellectual property in his own country, but not in China, they will not get protection in China. Therefore, it is very important to apply for intellectual property in different countries, especially the destination countries where the products will be sold. Next. IP holders can monitor IP infringement on the platform by, for example, through keyword search to find out whether there are IP infringement products on the platform. Next. And also, IP holders should familiar with the IP complaint procedure provided by the e-commerce platform. For example, Alibaba provides a channel for IP complaints. An efficient use of IP complaints can quickly resolve the IP infringement disputes. Next. As I said before, the notice from IP holder is very important. It should include the official evidence that the infringement is committed. So the effective notification materials generally include the following 6 items. The information of the IP holder, contact information and address, and then the IP certificates, and the third, infringing products link and screenshots. And I will not go through all the things because time limit. And the most important thing is take further action to the relevant administrative department or the court, because after 15 days, the product's link will still be visited. Thank you for listening, and I will return the microphone to the moderator. Thank you.
Thank you very much, Professor Ming Xu. While you are still on the microphone, give me 1 more second, because we already received 1 question. I think it's most efficient if we directly answer it. You referred to the 15-day period, and the question is whether it's 15 normal days or 15 business days.
15 normal days.
Okay,
according to
thank you very much.
law.
Great. Okay, so we have already tested the Q&A function. That's very good. And without further ado, we will move to the next keynote from Professor Dr. Peter Georg Picht. And we will now switch off our cameras that we can follow Mr. Picht.
Hello, and thank you very much for having me today. It is my pleasure to speak at this online conference about the legal framework for the intersection between artificial intelligence and intellectual property law. Next slide, please. Let us look first at some market data. As you see from the graphs on this slide, the acquisition of IP rights relating to AI is in rapid growth, as we can see by way of example from the patenting figures. Leading patenting jurisdictions are the US, China, and Japan, but also Europe. And the areas in which most AI-related patenting is going on are first and foremost transportation, but also telecommunications, life sciences, and the health sector, and maybe at a surprisingly low percentage, classical computing and personal digital devices. What seems striking, though, is that this intense patenting activity by companies in the field of AI-related technologies does not correspond to an equivalent disclosure of AI technology in the patent applications or granted patents. So, to put this simply, we can discern from the patent description that the technology to be patented or patented has very likely something to do with AI, but rarely is a specific AI system, in particular a combination between a specific algorithm and a processing unit described in the patent application. One may take this to mean that the companies are pursuing some sort of smokescreen strategies by using AI in their innovation activity, but not disclosing it, at least not to the full extent. And we will see later on in the legal part of this presentation what may be reasons for this. Next slide, please. You see on this slide a few areas in which AI research is particularly intense at present. On the one hand, those are, let me say, classical areas of AI activity, such as machine learning or logic programming. So these are areas in which AI systems are known to perform rather well. And on the other hand, we have areas like probabilistic reasoning or fuzzy logic, in which up to now, the human brain is much better than AI systems. So these are areas which, as it were, AI must conquer in order to move forward and to be able to support or even replace human brain activity in key new fields. So these are also areas in which the acquisition of intellectual property rights, protecting innovation in these fields, is particularly relevant. And the fact that intense patenting seems to be going on together with intense development activity in these areas further indicates that AI-related IPRs are being generated already, but we do not fully see this in the information disclosed via IPR acquisition proceedings, such as, for example, patent applications. One reason could be smokescreen strategies I have been mentioning regarding the previous slide. Another reason is very likely that companies use know-how protection instead of acquiring full-fledged IP rights, in particular IP rights that require, such as patents, a disclosure of the technology to be patented. As you all know-how protection is weaker than classical IP rights protection, but it does, on the other hand, not require the know-how to be disclosed. On the contrary, disclosure of know-how tends to take away the protection. So as one takeaway from these two slides, it seems that companies are using IP rights and disclosing AI-related technology at a level less intense than may be desirable for our societies and economies. So we can now turn to the questions, what the reasons for this may be, the deficiencies in the legal framework causing this situation, and also, based on that insight, what we may have to do to improve our legal frameworks in that respect. Next slide, please. This slide gives you an overview on a range of important issues regarding various types of IP rights. Let us start with patent law. One problem here is that the protectability of computer-generated innovation is in many jurisdictions yet unclear in its scope, and probably in many of those jurisdictions also too narrow to fully cover AI-generated innovation. One important reason is that traditionally, computer activity, which is relatively close to merely imitating the workings of the human brain without actually operating some technical system, some device, was considered not to be patentable. So a computer driving a machine that produces cars is patentable together with the machine, but a computer that calculates and forecasts traffic activity may not be patentable because that is, in a way, planning and calculating activity more familiar from the human brain, and hence it lacks technicality, even though such an activity by complex algorithms may be extremely valuable for many areas of our technology and economy. So rather clearly, the purpose of incentivizing valuable innovation clashes here to a certain extent with the traditional rules for patentable inventions. There is, as some of you may know, currently a very important case pending before the enlarged Board of Appeals of the European Patent Office dealing with such an invention, and it will be very interesting to see whether the Board of Appeals broadens at least the European patenting rules to cover in the future such innovation. To get to the next issue, even if AI-related innovation may be patentable as such, we can have a problem if the innovation is mainly generated no longer by humans, but by AI systems. Because then, from an empirical perspective, we may say that the AI is, as such, the innovator. However, this creates a patent law problem because either you designate a human being as the innovator nonetheless, but then innovator designation is incorrect or maybe taken to be incorrect. And this is a reason for patent invalidity in most patent laws, or you correctly state that the main innovative performance was done by an AI system, but then you clash again with traditional patent law, which does not allow for innovatorship of AI systems. And as a last patent law point, the conduct I call smokescreen strategy, namely the attempt to disclose as little as possible about AI systems resulting from an invention or having been active in the generation of that invention, may create problems regarding the replicability requirement of patent law. As you know, patent applications must describe innovations in a way that other market participants are enabled to replicate, to repeat that innovation, and to use it according to the purposes declared in the patent. Now, in particular, if complex AI systems are involved but are not being explained or even disclosed properly, replicability may suffer. And this may threaten not only patent validity, but also one of the important goals of the entire patent system, because after all, one key pillar of the patent system is the trade-off between the state giving the patent owner a very strong exclusive monopoly right so that the patent owner can monetize its invention, and the patent owner disclosing the innovation so that other market participants can either engage in follow-on innovation or, in any case, use the innovation once the patent term is over. When we turn from patent law to copyright law, we also have an issue with AI authorship, because copyright law is traditionally very strongly keyed to human authorship. Copyright wants to protect humans writing music or texts or painting beautiful pictures, but traditionally not so much systems consisting of processing units and algorithms. Now, there are AI systems, as you know, writing poems or painting pictures already, but one might be tempted to say nonetheless, oh, okay, if they can't get copyrights because copyright requires human authorship, that's not so much of a problem, so no need to reform copyright law here. However, think of the fact that copyright is the main IPR, the main intellectual property right for the protection of software. And software is today no longer something that you use merely on your computer when you want to do a calculation or write text on the computer, but something that underlies every product in every area of our daily life and business. The internet, smart watches, smart refrigerators, the entire database health system, everything is run with and by software to a very important extent. So the availability of protection for software has huge economic implications. And software is already and will increasingly be generated not by humans coding programs, but by smart algorithmic systems. So you cannot be possibly of the opinion that it would be irrelevant whether software generated by such systems can receive copyright protection or not. At the same time, the broader we extend copyright protection to software, the more virulent becomes the problem that copyright is usually not registered as opposed to trademarks or patents, for example. So it's very hard to know whether there is copyright on a particular piece of software and who the owner of that copyright is, leading to a very large liability risk because you very easily infringe copyrights on software that you don't even know about. And the spreading of software driven by AI generating such software will further increase this problem. Let's turn to know-how. We have already said that know-how is arguably a key protection right in the area of AI systems, amongst other reasons because it is relatively easy to get and it does not necessitate disclosure of the innovation to be protected by know-how rights. However, it is far from clear how effective know-how protection for AI-related innovation really is. For one thing, it is not at all clear in many jurisdictions whether primary and or secondary data used by or generated by such system actually qualifies as business secrets. And furthermore, at least some jurisdictions, such as now the European Union, request reasonable protection efforts in order for an information to qualify as business secret. So the owner of such AI-related information must implement something like a reasonable protection scheme, although nobody really knows what that means with regard to AI systems. And if the owner doesn't do so, the know-how protection may be lost. Now, as time progresses, let's jump right over to data rights. We can talk about further know-how issues and data protection rights in the Q&A session. So there is a worldwide debate on whether and how to protect ownership of data more strongly via intellectual property rights or new forms of intellectual property rights, or something like data property or data ownership right. And at the same time, there is an increasing level of data protection around the world. As you know, there are relatively strong data protection rules in the European Union and in some parts of the US now, in particular California. Other jurisdictions do currently have a somewhat weaker system for protecting personal data, but the picture seems to be changing worldwide. And these already existing data protection rules do, of course, interact very strongly with the IP protection for AI-related innovation, because after all, what AI systems digest and work with are data, and what they generate are data again. And much of this data is personal, at least according to the rather broad definition by EU data protection rules. You can, to a certain extent, operate more easily with personal data if this data has been anonymized. But the calculating power of advanced AI systems does not have a very hard time to de-anonymize many of the data AI systems work with. So to the extent data protection enforcement is getting stronger, this may also hamper data processing of AI systems and lead to the question whether we need to cut back on the protection of personal data when it comes to mass data processing by AI systems. So overall, you see there is a broad range of issues with the traditional IP rights system, which doesn't make it all that surprising that some suggest creating novel types of IP rights with regard to AI-related innovation. Personally, I'm rather hesitant in that respect because we already have a very dense IP rights grid, and the question is whether the creation of new rights would not add to a sort of IP rights stacking or IP rights jungle, which can turn out in itself to harm the innovative dynamics in our economies. And even if we agreed to creating some sort of new AI IP right, we would have to decide how to frame this right. And in this process, we may meet many of the same problems we have with the traditional IP rights. So I'm, as you realize, a bit doubtful there, but we will have time to discuss this in the Q&A session. Now let's go to the next slide. This would be all from my side for the moment. I thank you all very much for your attention and Swissnex for hosting this great event. And I'm looking forward to your questions in the Q&A session. Thank you very much.
Okay, now let's welcome Mr. Melvin May, Associate Trademark and Patent Attorney from Lucian Law Firm, to give his keynote. Please, the floor is yours, Melvin.
Thank you, Li-Bing. Hi, everyone. This is Melvin from Lucian Law Firm, a member of the Rouse Network. Today, I would like to share some of the high-level information and my personal thoughts on the megatrend in our business landscape and its implication on brand owners from the lens of intellectual property. Next slide, please. I raised this topic because if you look at today's business landscape, I'm sure that you will see that everything is moving online, that everything is going mobile. All these are made possible by mobile technology. China is now the world's largest and most dynamic mobile e-commerce market, thanks to its huge number of mobile device users. So brand owners doing business in China are experimenting with new ways to stay competitive and to adapt to the changing competitive behavior and consumer behavior. Next slide, please. So first is the changing competitive behavior. Brand owners are looking for expansion into new areas by embracing mobile technologies. You may see such as the mobile apps, connectivity, positioning, or digital payment infrastructures. So today, boundaries between industries blur. you can see that many consumers, product manufacturers are moving away from the wholesale distribution mode and transitioning to a direct-to-consumer retail mode that allows them to sell and ship their goods directly to consumers. You can also see some fast-moving consumer goods brands are moving and forming some co-branding partnership with others. And even it is reported that many luxury brands are moving into hospitality and travel business, looking for new opportunities. So brand owners are competing with others in a brand new way that they might not be very familiar with and are facing challenges from established brands, unfair competitors, counterfeiters, and infringers in that new area. So this would have two implications. First is the great efforts required in acquiring intellectual property rights. If you look at the left-hand side, you will see that there is a chart which is the number of the trademark filing numbers received by the Trademark Office of China from the year 2000 to last year. So this number shows that the number of the trademark filed in China has been on the increase over the past 2 decades. And now China has the world's most crowded and largest trademark register. So I remember that the record number is the 25.2 million live registration by the end of last year. So last year alone, China Trademark Office received over 7.84 million applications in that single year. So this is a very incredible number. So an extremely crowded trademark register suggests the greater difficulty faced by brand owners in acquiring new IP rights. For example, the trademark, due to the depletion of available marks. And in the meantime, globalization requires brand owners to use the uniform marks across all markets. So this also adds to the difficulty faced by brand owners. And also, some bad actors, such as trademark squatters, are also joining this game and has been a very big headache for brand owners doing business in China. The second implication would be the greater caution required in using and enforcing IPs. So as you can see there on the right-hand side, the brand owners are facing challenges from competitors, as well as some bad actors like counterfeiters and infringers. So all these parties can hold conflicting prior rights. So in the traditional perspective, if you need to use a new name, you need to do a proper trademark clearance search and patent freedom to operate search before developing and launching a new product is vitally important. So another thing that brand owner could not afford to overlook is the PR risk. That is the risk of being labeled as an IP bully as a result of enforcement efforts that go too far. So powerful brands are very, or can be very assertive in enforcing their IP rights. And they are always expected and entitled to do so because of their strong IP position. However, if that effort goes too far, or let's say an assertive but legally baseless claim can lead to a defense by the target, who might take such a legal message of a brand owner to social medias and use negative publicity to label the brand owner as an IP bully. So this is something that brand owners needs to be aware of. Next, please. So that second part is the changing consumer behavior that is also posing some IP risks and challenges to brand owners. Today, people, especially millennials, are relying more heavily on their smartphones to do things, including shopping. So we see there is a transition from offline shopping decades ago to online shopping, and now to live streaming shopping in China. This is a very hot topic. So live streaming is now evolving into a combination of social and e-commerce tool that enable brand owners to engage more directly with consumers and also offer consumers more immersive and personalized shopping experience and social engagement. So according to a survey, you can see from the at the right-hand side, the 4 major types of goods most bought by consumers through live streaming platforms are clothing, household goods, food, and cosmetics. Next slide, please. So while the brand owners are benefiting greatly from such kind of live streaming or online e-commerce, it is also important to be mindful of the IP challenges in various aspects. So we see at least there's 4 levels of challenges. First is speed to market. So in this e-commerce business environment, everything expecting that the goods and services are rolled out at faster and faster rate. Brand owners are allowed less time to clear new marks for registration and use, or to come up with new inventions or new industrial designs to market their product offering, or dealing with infringement. So time is always of the essence, and this means that we need to do things right in the first place. The second is the crowded playing field. So mobile marketplace enable consumers to shop around for the best product at the best price in an instant. So brand owners are being brought together to the same virtual space. So they are facing one common challenge, that is to ensure that their products stand out from the product of their competitors in the first place. So they need a large number of strongly enforceable and visually appealing IPs, such as nice trademark and industrial design. And this also accounts for a growing number of IP disputes. The third is the legal pitfalls. Take, for example, you can see some legal pitfalls in terms of unfair competition, advertising, regulatory, or even traditional IP perspective. If the goods are compared in a way that is found to denigrate competitors or use false or misleading information, that can be considered an unfair competition. Or if there is a funding of IP infringement, the infringing party can be liable for a huge damages because the profits can be achieved in the live streaming context. A very high profit can be achieved within just a few hours. So bad actors are also flocking to the live streaming platforms due to their huge user base. So these are the legal pitfalls. The last part of the challenge is the reputational risk. A brand is ultimately about the trust by its consumers. So these live streaming platforms allow consumers to share thoughts and experience on the product they buy. But negative comments or reviews can be spread in a very short space of time by users, competitors, or even trolls who attempt to use their personal experience to influence potential users or just to tarnish the brand. Next, please. So in closing, I think one thing that is vitally important is that each brand needs an IP strategy. A good and the smart strategy can guide all IP-related activities from IP acquisition to utilization to enforcement. And it can also ensure that the budget is wisely spent. So developing a smart and a viable IP strategy requires the brand owner and its outside counsel to sit down and to have a deep level conversation. And this is always something that we recommend. Thank you.
Thank you very much, Melvin, for sharing these insights with us. So with that, we will turn to the Q&A section. And I would like to start first with a question to Dr. Ming Xu. The first question is about e-commerce platforms again. So if the e-commerce platform does not fulfill its obligation to delete infringing products, will such e-commerce platform have to bear administrative responsibility in addition to civil liability?
Yeah. So if an e-commerce platform fails to take necessary measures, the relevant administrative agency of intellectual property shall order the e-commerce platform to take corrective action within a specified period. And after the specified period, if the platform fails to do so, it shall be fined not less than 5,000 RMB, no more than 500,000 RMB.
Okay, thank you very much. So quite severe consequences. Thank you very much, Dr. Xu. The next question I will take from the Q&A section, and it is addressed to Professor Picht. And he refers, so the question is from Raphael Zumsteg-Yuen. Thank you very much for your question. So Professor Picht, if you are there and can hear us, the question is whether you could share the name of the AI IP case that is still pending, which you referred to during your presentation.
Yeah, I'm happy to do that. I suggest I just post the relevant case information, the case shortcut in the section, in the chat section, because it's easier to find with the number. Would that be an approach? Can you hear me?
Yes, yes, we can hear you. So it's great if you will share the case in the chat or later with.
Right, I share the case shortcut. That's much easier.
Great, thank you very much. So then maybe we can directly go to the next question to you, Mr. Picht. So do you know about any international council that looks at the IP rights of AI, and what are the latest developments in this area?
So if I may ask back, international counsel in the sense of a lawyer advising on that?
So I don't know exactly. I think the question comes from Helen Lowe. I interpret it as some sort of international body that is dealing with this kind of question.
Right. So here we have one very important development is the WIPO consultation process on AI and IP. The WIPO has already issued a questionnaire to be answered by the national patent offices. And I have contributed to the statements by both the Swiss and the European Patent Office on that. So there will be at least one further round of consultations between the national, representatives of the patent offices this year. And then the WIPO is going, so there is an initial report by the WIPO, which is available online, and I recommend, you can just Google it. I recommend reading it. It's very interesting. And we will have a more, substantive substantial report later this year, or I suppose Q1 or Q2 2021. And at WIPO, there is currently accumulating really a very high level of knowledge on that. So that is something that I would keep, in view. The initial statement by the European Patent Office and the initial additional rules by the European Patent Office on AI and IP have, to be frank, been a bit disappointing, but I hope the EPO, also realizes that there are really, truly new issues and that they cannot, simply extend the existing rules with some minor modifications to what is going on there. So I expect the EPO to become more active in the field as well. And also I must say that the Swiss Patent Authority is starting to be very active. It has commissioned a major study on the topic in which I am involved. So there we will see also interesting results in the course of 2021 approximately.
Thank you very much for this.
Does that answer the question? Sorry, does that answer the question?
Let's hope so. I think it was very comprehensive. So let's see whether we get the follow-up question. Otherwise, let's turn to Melvin. There is one question from the audience for you. So have you personally encountered any trademark issues raised in live streaming so far?
Personally, I have not been have the chance to deal with a live streaming legal issue personally, because that live streaming boom is very recent. As I remember that the first live streaming platform came into existence in 2016, but the popularity exploded just at the second half of last year. So we see that this is a very booming industry. But I do think that this is the future trend of the online e-commerce marketplace, because we see a lot of online influencers and CEOs or even government officials are joining the live streaming salesperson group, and they are also promoting all sorts of goods and services. So we do think that this will be a future trend. But let's see what kind of a realistic legal issue will pop up. Thank you.
Thank you very much. So maybe then let's turn to the actual legal issues that you have already encountered. So if you would have to name the top 3 that caused the most trouble in China when it comes to IP law infringement, what would those top 3 topics be?
Okay, if I answer this question by using one phrase, that would be the smarter adversaries, because every brand owner is encountering smart adversaries. So if I put it into 3 issues, the first would be the reduced visibility of infringing acts, because not only the business mode is evolving, the bad actors are also evolving, making full and taking advantage of this digital age. A number of years ago, there are counterfeiters who copy just exactly what a trademark looks like, what a bottle or what a product looks like. But now they are evolving into unfair competitors or smarter infringers. We see a number of cases in which the trademark are very distinguishable. Industrial designs are visually different, but they copy the theme or the color of the brand, fabricate some similar brand stories, set up similar product lines, or even claim that they made in Germany or made in Switzerland to give consumers a very false impression about the good quality. So these cases needs to be dealt with by pushing the boundary of the current law. The second thing I noticed that is the new ways of doing things illegally. Take, for example, the registry enforcement. Trademark squatters have been a very big headache, and they now hold a very large number of marks, imitating famous marks of others in a very tricky way, to the extent that the law is not clearly violated. So they then offer to sell back the mark to the genuine brand owner or make some challenges. Also, if you take a look at the online market enforcement efforts, selling counterfeiting product via WeChat maybe is one of the challenging issues. Usually pictures or prices of the counterfeiting product can only be shared after the peer-to-peer communication established between the infringer and the buyer. So this reduced the visibility of the infringer acts from the real brand owner. And this is also a brand new way of doing things illegally. The third issue, as I mentioned in my presentation earlier, is the legal issue are often intertwisted with other issues like a PR issue. So more often than before, brand owner needs to look at both the legal aspect and the PR aspect and keep a balance. But I do think that it's quite challenging to distinguish a legal issue from a PR issue before taking the right action. Thank you.
Thank you very much for this comprehensive answer. And I think we have time for one more question to Dr. Ming Xu to close the Q&A. So the question to you is, in cross-border intellectual property disputes, are there any special legal requirements for evidence coming from abroad in civil litigation in China?
Yeah, if the evidence is obtained outside China, it must be handled in accordance with China law and regulations. For example, if the evidence is in a foreign language, it needs to be translated into Chinese, and then it can be adopted by the court. So there are some special thing to the evidence which obtained abroad.
So do you think that parties or foreign parties litigating in China, that they may face special challenges other than admitting the evidence that they may want to submit?
Yeah, also the evidence is very easy to get through e-commerce platform because they have the screenshot. But if the screenshot is obtained in their own country and they want to file a suit in China, they have to translate it into Chinese and also notarized, and then the court can adopt the evidence. So my suggestion is, if these things is too complicated, this company can cooperate with the local IP law firm, such as Marvin May. He is very professional in this area.
Thank you. Thank you. Okay.
So I think on this note, we will conclude this Q&A session because I see there is nothing more coming from the audience. So let me thank you at this stage. Thank our speakers for their valuable time and contributions. I personally learned a lot today and I really enjoyed moderating this session. Thank you again, SwissNext, for organizing such an inspiring webinar on a very relevant topic. And now I wish you all a very pleasant weekend, and I hand back to Libing. Thank you very much.
Well, a great appreciation to Dr. Xu, Professor Dr. Pisht, Mr. Melvin May, and to our moderator, Sabine. Thank you for your available time and your deep insights. Well, to the audience, if you have more questions, please send them to the email address that you see on this slide. We will transmit the questions to our speakers and give their feedback to you. You are also more than welcome to scan the QR code to follow us on LinkedIn, WeChat, and subscribe to our newsletter to receive information about our upcoming events. So thank you very much for your active participation. Wish you have a nice day. Bye.
Bye, thank you.